All right. Hi, everyone. This is Curt
And Brad Pinsky.
and we are here for another edition of Fire Law Roundup for February 26th of 2024. Brad, go ahead.
Let's go to Florida because again, it is winter in Syracuse and I want to go to Florida. So we are going to Tampa where a firefighter was terminated for falsifying EMS training records. He was, first of all, forging somebody else's name, and then at least he was giving himself good reviews. So that I guess was the important part. But and the interesting part though, and I hope I don't upset people, but to defend himself, it appears that he then tried to bring out false allegations of racist conduct.
I think that happened before. I think it's kind of hard to tell. It's kind of hard to tell. It may well have been, it may not have been, but I think in February he made the first claim.
Right,
In
about discovering a monkey hanging from the ceiling.
Right, exactly. So in February he made the first claim about the monkey hanging from the ceiling, which turned out to be somehow associated with Busch Gardens, and they have a
I did
primate
not
exhibit.
understand
And
that. Yeah.
and well, there was a picture on in the news. I got some of the information from one of the news stations down there, and it looked like either a rubber or it looked like a gorilla, but it looked like it was hanging from the mechanism for the overhead door,
But it
almost like
wasn't
you.
hanging, right?
No, no, no,
When
it
you
wasn't
when
hanging
you
like
read
that.
it,
No,
it
but
looks
it
like
looked,
they meant hanging.
like you have and again, I don't know. I'm just going based on the picture, but you have the latch above the overhead door for when you lose power, you pull it, and then the door can operate manually. And it looked like they were you. I don't know.
It
I
looked
could be totally
climbing,
wrong.
not
No, no,
anyway.
it was
Oh,
just hanging so that you could pull on it. It looked like it.
oh,
It looked
okay,
like
right,
it
right.
looked like it was actually. I don't know, but at any rate,
That was
apparently it
February.
had more to do with Busch Gardens than it had to do with that. So that
Right.
was February. Then he made a claim that someone had defaced a picture of him and placed it in his locker. And then there
Right.
was a factual question about that. That the police actually did a major investigation. Sounds
Yeah.
like interviewed
Yeah.
32 people, and but that turned out to be inconclusive. So that was June, but apparently in July they started this investigation into his EMS documentation training. Now here's the thing, I don't know about the overlap,
Right.
because whether the investigation predate, like the investigation might have started in July into the falsification, but the activities predated that, or what? So I know where you're going with this, and I think it's important that we talk about it.
Yeah, it ties. Look, it
But
ties together. He
yeah.
knows at some point that he needs to falsify report his
Mhm.
evaluations, right? And he obviously knows he needs to do that because I presume he thinks he knows he's going to get bad evaluations. At the same time, is something you've talked about a lot of times. He's trying to protect himself by
Mhm.
saying, "Well, I'm a target of a victim of racism and racist
Yeah.
activity." So if he is terminated, he can say, "Oh, you can't do that. You did it because you're retaliating or
It's
whatever."
retaliation, yeah. Yeah.
So
So
it
now
all
I think
ties.
what I think the devil in the details here is, was he retaliated against? Okay.
Yeah.
Was it actual retaliation? Because the timing here is a little bit curious. Or was he trying to construct some sort of a, like, teeing up a retaliation claim? And that,
Yeah.
that's going to be a question of fact. It'll see, I'm sure it's going to come out. He's already filed with the EEOC a race
Yep.
discrimination claim.
Yep.
So, we'll see. We'll see. But
Yep.
you
Yeah.
know,
I just, I'm not trying to characterize him. We don't know as much, but it is a typical pattern amongst people who are bad employees to try to find a reason why they know they're going to be terminated. So they threaten you, so hopefully you fear, oh, I don't want to be accused of that. Listen, people,
right.
if you are right and
Yep.
the employee is wrong, you terminate them. You do not get intimidated, right? Because then eventually they will build a good case against you. But if they're a bad employee, let them go, right?
Yeah.
Don't, and if you haven't been retaliating, if you haven't been discriminating, don't worry about it. I
Mhm.
mean, that's what it is. But you
Yeah.
let people like that stay around, And now you really are going to at some point trip up and hand them a victory. So, okay. The most interesting part, if for the listeners, if you have not, and you're going to hear it now, but the most interesting part about the next case about a Washington captain who's didn't get killed, he got rescued, but suing for injuries about being, he was sent in, him and his crew were sent in to a property where they were told there was no life safety issues. And they claimed that the danger they faced was beyond the risk, beyond the validity of the risk, right? It wasn't worth the risk because they were told that nobody was inside. Now, I have my own feelings about that, but the most interesting part of this is Curt's, your comments, and we should share them here, but I think I just summed it up, right? That's what it is. They're claiming, this lawsuit is claiming that the crew, the captain or the incident commander made a bad and an unsafe decision, which may be true, maybe not true, when they sent a crew in to search, right? And they were told, and I don't normally rely on that, but they were told that there was nobody inside. Now, I didn't know what type of building this was. If this was a residence where like mom and dad said, yeah, everybody's out, or was this a vacant structure where you don't know, or a commercial building where you don't really know who's there? I wasn't sure because we don't have all the facts.
Yeah, we don't have a copy of the complaint. I tried to get a copy of the complaint and I couldn't get it.
But I think the type of building matters. That said, it matters. It matters to the IC's determination. But that said, you said correctly so that a lot of people are becoming very nervous about this. Listen, we cannot lose a lawsuit for making a decision, whether it's good or bad, is right. But we make a discretionary decision in an emergency situation, as long as we didn't violate a strict policy. If it's discretionary, we're protected for this exact reason. Because the opposite would be true, by the way. If they found a victim deceased, even though they were told, right, they would have been sued and probably lost. So you didn't search, even though you could have, and it was reasonably searchable, but you relied on some person walking down the street, who knows, right? And that's why I really want to know what type of place this is. But
all I could think of, but I had emails, I had text messages coming in. Oh my God, does this mean we can be sued for everything? It was like people who were running around like their hair was on fire. It was like, and this is just
for anything.
How many lawsuits do we see like this? I mean, I could put up one or two a week. I've got to be selective about the ones I choose to cover. But this one, whether it was the headlines, I'm not sure why, but so many people get upset about it. But the bottom line is he's a captain. He's got 30 years experience. He goes into a building and then he gets hurt, which, is tragic. And I'm certainly, not poo-pooing that part of it. His injuries are real and so on. And his wife certainly is suffering from, the aftermath of that just as much as he is. So, but at the same time, if you're going to sue your employer saying that you should have been aware of the dangers that you were putting me in,
right,
you're not dealing with a rookie who was sent in by an experienced officer. You've got a fire captain who has responsibility for himself and his crew.
Right. And I don't know how they get around workers' comp anyway, but that said, all of the other stuff.
I know. I just don't understand. And again, my point I don't like to editorialize in the blog itself. I like to just provide the facts. But this is just, he's trying to claim that the incident commander was really beyond the bounds of taking risks, that ignored obvious risks that were undertaken unnecessarily. All right. So indeed, if the incident commander was disregarding a known and substantial risk of harm, recklessness or gross negligence or whatever it may be, is really beyond the pale, then why is you with a captain with 30 years experience,
right?
Why didn't you recognize the danger?
Right.
And say, whoa, Chief, no disrespect, but we're not going in this building. It's too dangerous and there's nothing to gain here. We're not going in because I know, I mean, I've been a chief a long time in, double digits. And I expect my officers, if I give them an assignment, get the roof, and the roof is unsafe, I don't expect you to go up the ladder, doop, de doop, de doop,
It's
and
funny you say that, because we had a house fire, right? Our war stories, but it's not even a great story. But we had a house fire and our hydrant froze. We had no water, so we're losing the house. We had to start a tanker shuttle in, but hydrants freeze, so we had no water. And I thought the only way I could save half this house is trench cut the house. So I said to the crew, I said, "Listen, why don't you go up, trench cut it? We'll save half of it." And they're like, "Chief, it looks dangerous up there. Like what we're seeing maybe isn't what you're seeing, but it looks dangerous." And they said respectfully, "If you really want us to do it, we'll do it. But is it worth it?" I'm like, "If you think it's unsafe, I'm not sending you up there. I'm just right. You're not going to be that guy." So I agree with you. They did what they should have done and said, "We don't think it's safe, but if you want, we'll do it." And if they don't think it's safe, what's worth the risk? Right.
I mean, I've given firefighters assignments, and they say, "Chief, we cannot do that. We can't do it." You know, they get up there on the roof or they get in the building and say, "We're backing out," whatever it is. And and you know what? I'm not there. It's their responsibility to make that judgment.
Right.
So I don't know. I just, I think, I don't know the circumstances of this case, but I do know that if the captain here, Captain Weber, if he is going to prevail, he is going to have to overcome that defense.
Yeah, and look, it won't even get to that, because workers' comp, you can't sue, discretionary can't sue, public duty doctrine can't sue. He's not even going to get to that argument. So everybody listening, don't worry about it. And look, they're all probably angry. I get it, but this isn't how you deal with that, right? Lawsuits in this case are only going to make you look like the bad guy. And if you think that it needed some redress in terms of additional training or better procedures, that's the way to proceed. But this way is a dead end for you. It doesn't matter how good a lawsuit you had. We've seen people who died, right, from the same thing. You cannot win. You cannot prevail on this type of claim.
Yeah, even on workers' compensation exclusivity, even if your employer was negligent, even if they were careless, and even in many states, even if you were reckless,
right,
it's not going to be enough to allow you to recover.
Exactly. And this isn't going to be reckless, because again, you're going to hear a million fire chiefs say, "How many times have we been told there's nobody inside?" And there is. You know,
just because there's nobody inside doesn't mean you don't go in.
Right.
Right. Let's face it. We do go in. We do. And he was performing, from what I understand, it sounded like he was opening up pulling ceilings, which is, overhaul.
That's not just search. That's locating the fire to help the engine.
It's overhaul. And so, we do go in, but I mean, if there's a risk of collapse, if there's a risk of the fire extending and trapping you, then no, those are all the things that you have to take into account. But just because the building's on fire doesn't mean we're not going in.
Right. It's not a good suit. Sorry for your injuries. Absolutely. But
absolutely. Absolutely.
All right. Well, let's go on to something that is probably a better suit. And we're going to go to St. Louis, where we have a wrongful death suit. And the facts are super easy and very disturbing in some ways. So look, there's a medic unit, an transporting ambulance unit that is dispatched to a motorcycle accident, serious motorcycle accident. As the unit is responding, and I guess there's also a first response non-transporting unit that is responding or does respond, but which is important to me, but not that important. But a rock or something hits the ambulance. The ambulance, maybe pursuant to policy, we don't know yet, pulls over, discontinues its response to what's presumably transmitted as a serious motorcycle accident. And they wait for a significant amount of time. It's like 20, 30 minutes. They delay response. Now, listen, we don't have the other side of what was on the radio, what was happening, what's the policy. But in any event, then they get cleared by a supervisor after a good amount of time and proceed in. There was no other ambulance that had responded. There are a first response unit on scene providing care, but they needed to be transported. And now the lawsuit is for the wrongful death resulting from the delay. Let's assume for the moment that they will prove, as we always talk about proximate cause, that they could prove if you got there earlier and transported earlier, they were survivable injuries. So then let's forget about cause. Let's assume there's cause. Big assumption, but let's assume it. Normally with these traumatic type of injuries, 20 minutes isn't going to make a difference. It may if it was something like brain death or something, but right, because that's easier to prove. But here, let's assume cause is taken care of. And now let's just jump to the negligence. They make out a good case. We don't know more, but they do make out a pretty good case for negligence. You got hit by a rock. You didn't hit a person. You didn't hit a car. You got hit by a rock or something. That does seem strange that you would discontinue and not keep going.
The thing that I find a little troubling, and I spend most of my time with Providence, so certainly smaller than St. Louis, but on a sort of a scale of that nature. And at the time we had 5 EMS units. I think they got 7 or 8 right now. But when you're involved in an accident, you're not the only EMS unit in town. Okay. Right. And what we would expect as leaders in the organization, what we would expect is the person who's in charge of that EMS unit, if they decide that they cannot continue, reports that over the radio to dispatch, and dispatch sends another EMS unit. Right. And if we're out of EMS units, we're going to get one in from mutual aid, but you don't just, oh, well, we got hit by a rock, we're going to stop.
Right.
And then wait 20 minutes and then respond in without notifying them that, so there's some,
and
we
don't know that they didn't notify. We didn't,
exactly.
Right? Because that ambulance doesn't know if there are other closer units.
Absolutely.
And right, we always try, you and I always try to give both sides of this, and we don't know if the dispatcher said received and they never heard anything else, right? Who knows why another ambulance wasn't dispatched promptly and what they thought they knew. And again, I'd like to see the policy. I don't know the condition of was it hit by the windshield? Was it a dent to the truck? Did they think it was somebody that they hit and they had to get out and check? We get one side.
You get hit by a rock. You might think you get hit by a bullet. You don't know until you stop and figure out what was that loud bang. You might, you might not know. But the bottom line is that if the officer of a unit feels they cannot continue for any reason, they cannot continue, they should promptly notify dispatch, and dispatch has got to fill in an additional unit.
Right.
If you're going to a fire, it's the same deal. So that's a little bit troubling how that happened. And then the causation part, I think,
that'll be tough. Trauma is tough, and a trauma arrest is even,
and the burden's going to be on the family to prove that, but for the delay in the EMS unit, he would have survived. And maybe they can. They're going to take some expert testimony to establish that, but maybe they can. Probably is going to be an uphill battle.
Yeah, it is. It is. But, I would encourage everybody to review your policies on when do you stop, when do you continue. Look, if you hit another car, you got to stop. But we've all been faced with.
Not necessarily. We had a pretty good rule, and again, I helped to rewrite the rules a couple of times in Providence, but I didn't have to do very much because the people who had written the rules that we had, they go back into the 1800s. I've got several versions of our old
horse
rules
drops
and regs,
a shoe,
But it basically says that if you're involved in an accident or you otherwise are responding and you need to stop, the first in officer, we have officers on all of the units. It's at the officer's discretion as to whether they need to stay at the accident scene or whatever, or continue. Right. And if they feel that in the under all the circumstances that they can continue, they're authorized to proceed to the fire. Right. And I've done it both ways. I've gotten in an accident, and you in a big city, accidents it happens, so, but I've stopped at the scene and had other people go to the fire, and I've said, we're engine 8 and we will be back. Yep. But in the meantime, we're going to a fire. When the police get here, just tell them we're at, and then
look, I've left an EMT. I've kicked somebody out, said, you're going to grab refusals, whatever, stay here, and we're gone. And I've at least left a person, because the vehicle's not going to do anything for you.
Right. And that is one of the options as well, to leave someone at the scene. But if you're already minimally staffed and you're headed to a building fire,
Right, especially if you're first due, and look, and I like the idea of having a discretionary policy based on what type of call you're going to. Are you the fifth arriving to a CO alarm, or is there serious injury where they need treatment and it takes precedence over property? So the way I've written these is here you're considering factors, right? But try to weigh whatever you can. What are you going to, and what just happened in front of you? But the discretion saves you. You made a decision in an emergency situation, right? Unless no good person could ever make smart person could ever make would ever make that decision, I guess, right? I mean, you're going to a CO alarm and you just killed somebody in the car, but just keep going, right? Unless it's something so bad like that, I just can't imagine a court not siding with you made a determination.
Yeah, and again, if you just stop, but you don't continue and you don't tell anybody,
well, yeah,
that's that's a problem. But again, we don't know all the facts there, so
right. Okay, let's go to Ohio. There's something more going on here, but the facts are I'll make them pretty simple. So a citizen made a public records request of a volunteer fire department. Now, I don't know about every other state, but in New York State, the state's highest court, the Court of Appeals, has held that a volunteer fire company is subject to Freedom of Information Act. Interestingly, not the open meetings law, but the records, they say, are subject to freedom of information. So here you have the same thing, but the court says, look, somebody requested your records. I don't care, you're a volunteer. You receive public tax money. You are, for purposes of their records laws, you are required to provide them. Now that should be the end of the story, but they don't produce them. So then the judge issues an order saying you're going to produce them, and they failed to adhere to that order. So there's a contempt proceeding, and the judge says, and the judge makes clear that, or the magistrate says, it's you're playing cute, right? Because you produced these records, so we know you have them, but you didn't produce the same records for different dates. So the magistrate is really, and for everyone who doesn't know, a magistrate's just like a judge. They make recommendations to the judge. But the magistrate's really saying, you're doing something wrong. You're playing cute with the rules. And so holds them in contempt, which, by the way, is the right outcome. But the question is, why are they handpicking certain records and not turning others over? If they think there's a privilege, then most freedom of information laws have exemptions to them. So they could have said they're exempt, or maybe there's some reason why something should be redacted, but don't just ignore a judge. You're going to piss off a judge. And if it's a judge who says, I told you to do it, and you said, yeah, but we're volunteer firefighters, guess what? You lose. I thought
it's interesting too. They I don't know if you want to get into the nuances of contempt, but they said it was civil contempt, in that with the civil contempt, you can always clear the contempt by complying with the order, as opposed to criminal contempt, where it's criminal contempt, you're guilty and here's your fine, or here's your handcuffs, one or the other. But you're either going to jail or you're going to pay a fine. With criminal contempt, they characterize it as civil contempt, and I think they gave them a couple of weeks or so, through April. No, where is it here? They gave them a certain period of time to ensure compliance. So the fire company has the ability to I'm not sure I put the date in there, but I think they've got a certain period of time to comply with it. So I thought that was pretty interesting.
Yeah, September.
I think they could have went the other way. I think they could have went and said, you are now in contempt of my order, and $10,000 fine, or
right. And I got to tell you, if I was their attorney, I wouldn't be their attorney anymore. Don't put me as an attorney in the position of saying, the judge, my client, told me to come here with half the stuff you asked for. I'd be like, you know what? Don't put me there, because it looks bad to me. I don't need the judge yelling at me, and he will, or she will, right, to say, you get your client to do this. I don't like it, because it could lead to professional misconduct and all sorts of things against the attorney. So I'm shocked to have an attorney who's also playing these games. If you think there's a legitimate issue, fine, ask for a stay, get an appeal, whatever. But to disregard a judge like that,
we are
Bad idea.
officers of the court, and
Yeah.
to the extent we zealously represent a client, that's one thing, but we're officers of the court. The court orders you to do something, you have got to do it.
Right. You may not like it. You can appeal it, try to get a reverse, whatever it is. But at this point, no way. But I think, I don't know that states' freedom of information laws, but it's, we don't like it, but it is taxpayer money.
What I know about freedom of information laws nationally, this is the majority rule. Is that your dog running around the background?
No, I was looking because I'm going to do this. I'm going to move my camera. So you see that poster right there. That's the book we just wrote on the freedom of information laws.
In New York, yeah.
In New York, right.
Yeah, no, absolutely. And I know my state, Connecticut, I know the states that I've had to actually get involved in cases in, we volunteer fire companies are subject to the freedom of information law to the extent it pertains to financial records and incident records. Now, there's some
in
other
New York,
things.
it's everything.
Oh, really? Everything?
Yeah, the Court of Appeals had a very interesting statement. So that's why, right? It's obviously very state specific. But what they said in New York is, and this is one of our topics at our conference coming up. This court said, listen, we recognize, and this is very true what the court said universally. The court said, we recognize that there are some aspects of the fire company which are purely social, purely have nothing to do with taxpayer money. And we recognize that there's a big part which is municipal and taxpayer funded, and right. And the court said the problem is we can't draw the line anywhere. So since we can't draw the line between private and public, they deemed it all public. And that was actually their exact not the exact wording, but the exact language is we can't find a line. So it's all public. So
I hope other states don't go looking at that ruling.
Yeah, well, but it is the right thing, in a sense. And what they wanted in the New York case was bingo records. I don't see how bingo records are anything but private, except they said, but the money is used for a public purpose. I said, fine. So once it's used for a public purpose, but anyway, the state's court has spoken on that, so that's it. Okay, let's end up with a short, stupid one. But it is, I like how you choose these cases because as much as they're all different, somehow the same, but now we've got an FDNY lieutenant who's facing assault charges for allegedly, right? These are charges we don't know, but allegedly made physical contact with an EMT during an argument that occurred at an EMS incident. Listen, people, you do not ever put your hands on somebody else. Short of, you're saving them from something. Don't ever grab them. Don't ever touch somebody else, because it will never be interpreted properly. Merely touching somebody could be a battery. Threatening them may be an assault, but you put your hands on somebody, all bets are off. In any event, he was criminally charged and facing disciplinary investigation. Don't touch anybody.
It's
again, an
unfortunate.
allegation.
I think you just pretty much summed up the most important point of this, is that once you go hands-on, or even threatening, threatening to punch someone could be an assault. Assault doesn't require the contact, but once you have contact and, was the EMT injured? That's irrelevant.
Relevant.
The EMT doesn't have to be,
right.
Did the EMT even interpret it as a threatening gesture or whatever? That's not even as relevant either. The point is it was an unpermitted touching, and it could be a poke.
I've seen bumps. I've seen people they bump you. Oh, sorry, it was a tight hallway, but they, shoulder them. They've been fired. I mean, it's workplace violence. First of all, under federal law, your employer has to do something about it. But you file a charge against somebody because they touched you inappropriately, you're done. You're done. And FDNY has a very short tolerance for some of the stuff. I know because I deal with them on a lot of these types of things, and properly so. They don't have a tolerance for it. Yeah. So, well, that's the end. That was I really like having 5 short cases, but they're all so different. They're
different, and I think each of them is interesting and hopefully educational to the folks that are watching. So,
yeah. So,
Brad, we got your conference. We got
our conference is coming up April 4th.
Yeah.
But I want to say to all the people who want to do stupid things and end up on this, we like it. You want to sue for some crazy reason or do something you shouldn't be doing. You want to steal narcotics or assault somebody, more power to you. We'll cover you.
Well, we got your conference coming up with 3.
Yeah,
Oh,
April
it's a
4th to
month. It's
7th.
a month.
It's coming up.
Perfect. Yeah.
A
So
lot of
yeah,
great issues. So,
yeah, yeah.
but I
So
really, to the people who listen to us, not today, talk about HR things. I really look forward to someday when we take all this good stuff and do a 2-3 HR conference on the road. And hope if you guys are interested, we're kind of putting out feelers, right, to see if
yeah.
people want to email Curt and say, yeah, we'd love that type of thing. We'd love to do. We have it ready. I mean, we have so much stuff to put
So much stuff.
together. Yeah.
So much stuff. FMLA, ADA, just
Oh
discipline,
my God.
certainly sick leave. There's just so
Hiring
many
practices in general, termination, investigation, discipline, drug use, marijuana. I mean, there's just so many things, job duties, overtime, could take us days, but overtime issues, who's exempt, who's not. So many good HR stuff. So much good HR stuff too, that we'd love to do a in-person conference for you. So.
Yeah, hopefully that'll happen over the next year or so. We just gotta figure out a venue, figure out the logistics, and we'll make that happen. So, but we would really like your feedback. So if you think it's a good idea, reach out to us. You can post it on YouTube, post it wherever. Hopefully we'll see it. Email us. That's probably the best way, but happy to do it. So, all right. Well, that's going to do it for another edition of Fire Law Roundup. We'll see you again next week.